IRAs are free from creditors? Really? Is that true? Are IRAs not subject to creditors during a bankruptcy proceeding? Well, the answer is a little bit of yes and a little bit of no. Welcome to the Heritage Wealth Planning YouTube channel, my friends. This is the YouTube channel where we focus on building sustainable wealth, identifying ways to increase your cash flow, pay down your debt, reduce your taxes so that way you can live comfortably in retirement with your cash, and if you so desire, to pass down the stream to your heirs or even your charity. So I want to talk about an article. This is from 2014, and I think it gets overlooked a lot. Let me minimize myself out of the way here. As you can see, wait for myself. There we go. Because it's critically important that a lot of people are ignorant about, unfortunately. And here's the article itself from the Wall Street Journal. Unfortunately, it is under the paywall, so you got to pay to subscribe to read the full story. But I'll read this to you. This is probably one of the most seminal articles I've read in a number of years when it comes to retirement planning. So here is the headline: Supreme Court allows creditors to tap into inherited money. And I'm going to say, in a unanimous decision written by Justice Sotomayor, the court said inherited money, IRA money, not received from a spouse isn't protected in bankruptcy proceedings. Most types of retirement accounts cannot be accessed by creditors in a bankruptcy case, a rule meant to encourage people to save for their future. But traditional IRAs have spending restrictions that don't apply to inherited IRA money, other than in the case of a deceased spouse. The distinction should allow for different treatment of those funds by a bankruptcy court, says the justices, in a unanimous decision, by the way, 9-0. And that includes the liberals and the conservatives. Justice Sotomayor wrote, nothing about the inherited IRA's legal characteristics would prevent or even discourage the individual from using the entire balance of the account on a vacation home or sports car immediately after bankruptcy proceedings are complete. And that's the gist of the matter. She's saying nothing about the inherited IRA's legal characteristics would discourage someone from just going bankrupt and now taking out the money and buying a sports car or vacation home. And that might be a little facetious simply because you still got to pay income tax if it's a traditional IRA. If it's a Roth IRA, you don't. And I talk about that in all kinds of other videos, but she's spot on. At the end of the day, this is not retirement money. It is inherited money, which means you can use it on a sports car, vacation home, even to buy a pro football franchise, wherever you want to do. Courts in the past have disagreed over whether money that someone inherits from an IRA should get special protection. Bankruptcy law typically protects certain property that creditors would want to seize to pay down outstanding debts. But the inheritance issue came up in the case of a Wisconsin couple. Now listen to this. This is critically important. The inheritance issue came up in the case of a Wisconsin couple who in 2010 filed for bankruptcy with $293,000 in an inherited IRA. The money the wife received when her mother died in 2001. So let me break this down for you. Husband, wife's mom dies in 2001. She receives a significant amount of money from the mom. In 2010, they filed for bankruptcy. The gist for them was they don't want to pay their creditors, and they should not have to use the money that they inherited from their mom because it is still technically an IRA, which is 100% correct. Lawyers for the plaintiff and her husband, or I guess the defendants, I'm not sure. Anyway, lawyers for the couple who was filing bankruptcy and her husband argued that the money was off limits to cover debts that grew after their pizza shop had closed in 2009. So what happened was they opened a pizza shop. So the mom dies, leaves the woman, the wife, we'll say $200,000, whatever. It grew to 293 when they filed for bankruptcy. In the interim, they started a pizza shop, which since went bankrupt. So they filed for bankruptcy to get out from under the thumb of the creditors who gave them the money to open the pizza shop. They still had the IRA that she inherited from her mom. The bankruptcy trustee went after the funds to cover, among other things, a $74,000 judgment in favor of the restaurant's landlord. Last year, more than 45 million U.S. households had some type of retirement account, and overall value of those accounts topped $5.7 trillion. It isn't clear how many people file for bankruptcy with inherited IRA money in their possession, though. However, now we know for a fact, if you have inherited IRA and you think you can go and use that money to start a business or to go buy a vacation home or do whatever, and it's exempt from bankruptcy procedures, you're absolutely wrong. Now, here's the gist that you need to be aware of. Here's what's up. If I am leaving money to a child, all right, remember, this is non-spouse beneficiaries. Non-spouse beneficiaries. A spouse can inherit the money and is still subject to creditor protection. So I die, I leave it to my wife, Charlotte, and for some reason she goes bankrupt, the creditors cannot get that asset. It's because she can actually roll that money into her own IRA. It's hers, her IRA. She takes full possession of it as if I never existed. So in that case, it is subject to creditor protection. However, I die, leave it to Charlotte, she dies, leave it to the kids. The kids cannot take full possession of the IRA. Is what's called an inherited IRA, which means it's subject to RMDs, required minimum distributions based on their life expectancy. But their life expectancy in terms of the RMD starts today. They have to start taking mandatory distributions right now, not at 59 and a half. It could be 3 years old, it could be 30 years old. It doesn't matter. They must start taking RMDs right now. Whereas if it's an IRA owned by a real owner of it, me or my surviving spouse, we do not have to start taking mandatory distributions until we're 59 and a half. That's a pretty significant distinction. Ownership, mandatory distributions at 59 and a half. Inherited, mandatory distributions today. Even in a Roth IRA, by the way, there are still mandatory distributions for non-spouse beneficiaries. They don't have to pay tax on it, but they still have RMD requirements. So what happens? Now, you leave this money to your kid, and let's say little Joey's up to no good, and for some reason he goes out drinking with his boys, and he ends up crashing his car, and he gets sued, and he goes bankrupt. So all that money that you had left to little Joey in your IRA, because you were living like a pauper to make sure little Joey could live in a decent manner because you survived the Great Depression, whatever. I've seen this happen a million times a Sunday. You fly coach so your kids can fly first class. Well, now Joey has that money, and guess what? Creditors are going after it. And because of the Supreme Court ruling, again, this is dated June 2nd, 2014, they're going to win. The creditors are going to win 100% because that IRA is no longer subject to creditor protection. It is 100% available to the creditors to get. And all they got to do is sue them and get a judgment, like what happened in this case with the pizza shop owners, where they had a $74,000 judgment that they thought they could discharge in bankruptcy. No siree, Bob. So a lot of people, now you got to be very comfortable with who gets your asset, because if it is an IRA, 401k, what's called a qualified account, and you leave it to anybody other than your spouse, the simple facts are it could be subject to creditor protection, or it won't be subject to credit protection. It will be subject to creditors. Absolutely, no debate about that anymore. Unanimous ruling by Supreme Court. This will never see the light of day again. So it's etched in stone today. So what should you do? If you want to leave it to somebody and you're worried that they're going to sniff it up their nose or go blow it on the beach house or something like that, there are a couple of things that you need to do. First and foremost, because you got to think about the taxes that are going to accumulate to those people, to those inheritees who receive that money. It's going to be through the roof because they're taking a lump sum distribution. So you got to think about the taxes that they're going to pay. You got to think about the creditors who are going to have their assets potentially. They're going to get your money essentially because your heirs have squandered it by doing some unscrupulous things. I don't know, whatever it could be. So you got to think about all this. So if you're concerned with that, then what you do is you'll make your trust a beneficiary of your IRA. Generally, I'm not a big fan of that simply because you have to get a trustee involved. And a lot of times the trustee doesn't know what they're doing. And if they make a mistake, the trustee will certainly be subject to lawsuits without question. There's a cottage industry now about estates suing trustees because they weren't managed to the best of beneficiaries suing trustees because they weren't managed to what the beneficiaries felt they should have been. And remember, when it comes into money, families start breaking apart when money gets between families. I've seen that happen a million times. I'm sure you have as well. And so a lot of times people say, I'm going to leave my IRA to a trust, and I'm going to hire Uncle Jimmy from Tulsa, Oklahoma to be the trustee, even though I live in Los Angeles, California. Does Uncle Jimmy have a good relationship with your children? Well, maybe, maybe not. Well, Uncle Jimmy's going to have a whole lot worse relationship shortly when one of your kids is begging Uncle Jimmy for money from the trust and Uncle Jimmy's standing firm, or even worse, Uncle Jimmy is not managing it very well and he gets sued. So there's lots to go on there. And on top of that, Uncle Jimmy could charge a fee. Now, Uncle Jimmy probably won't charge a fee, but he's probably not going to do a great job either. So a lot of people instead do a corporate trustee over at the bank or something like that. And the corporate trustees aren't cheap. You're talking easily 1 to 1.5% on the assets under management. So once you have, $1 million, it's going to cost you $15,000 a year just for the trustee fees, and they're going to charge you investment management fees on top of that. So you're talking $25,000 a year just to manage your IRA. So that way little Joey doesn't have to get his hands on it and squander it to the tax man or to the bankruptcy court. So what do? You enjoy it while you're alive. That's what you do. You enjoy it while you're alive. And if you really want a little Joey to get some access to it, start giving it to him while you're alive. You can enjoy watching him spend it. Maybe little Joey will show a little bit more responsibility as each and every year passes by, and you slowly feel that, hey, he's doing better and better and better. Yes, you're going to have to pay tax if it's a non-IRA on your distributions, but essentially there's no gift tax, my friends. Everyone gets wrapped around the axle on the gift tax annual exemption. If you gave little Joey $50,000 today, yeah, you are going to have to file an IRS form 709. It's a gift tax form. It's a one-pager, no big deal. But at least little Joey will get the money. It's not subject to any gift tax to him or to you. No inheritance tax to him or to you. Just here's a check, little Joey, go crazy. And hopefully you can see that he's learned enough where he's no longer squandering it. He's actually putting it to use, like the talents, the parable of the talents. And then that way you can feel a whole lot more comfortable that little Joey is getting his stuff together. He can manage that property better and better and better. And that is a wonderful strategy to just start saying, here, Joey, I'm going to give you $10,000 a year. I want to see how you manage it. And if he's squandering it on, high living, then you probably want to be careful on how you donate it to him. You might want to donate to a charity instead. It's completely up to you. But at the end of the day, you got to understand, Supreme Court allowed creditors to tap in inherited IRA money. Great firm, Phil Cavish. I follow this guy. He's got a good article on this as well. And again, he just talked about what we just talked about. Unanimous ruling. Sotomayor wrote the author of the ruling, and there's a lot of good stuff in there. But at the end of the day, my friends, inherited IRAs are not subject to creditor protection anymore. They are absolutely subject to creditors to be able to get that money in an inherited IRA circumstance. A spouse is not an inherited IRA. Just be advised that a spouse is not subject to these rules as non-spouse beneficiaries. No longer have creditor protection when they inherit IRAs. All right. Have any questions, thoughts, concerns? Post them below. I'd love to hear what thoughts you have on IRAs in particular, inherited IRAs, what we're talking about, IRAs generally, inherited IRAs in particular for sure. Lots of strategies that we'll get into about how you can deal with your IRAs, a tax bomb that's in there and whatnot. As always, subscribe, hit the little notification bell, that little bell down there to be notified of future content. Have any questions, thoughts, or concerns, go to heritagewealthplanning.com or send me an email at josh@heritagewealthplanning.com. And we'll see you next time on the Heritage Wealth Planning YouTube channel. Thanks, guys.